Welcome to our continuing 2017 educational webinar series. I am Catherine Short, Partnership Marketing Specialist for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business. A hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Robert Liles of Liles Parker and Paul Weidenfeld of Exclusion Screening to be presenting the critical role of background checks and exclusion screening in risk management and compliance programs. Mr. Liles focuses his practice on healthcare fraud defense, internal audits, investigations, and compliance and regulatory matters. Mr. Liles has represented a wide variety of healthcare providers in administrative and civil proceedings and in connection with internal compliance reviews. After the passage of HIPAA in 1996, Robert served as the first National Healthcare Fraud Coordinator for the Department of Justice Executive Office for U.S. Attorneys. In this capacity, he advised prosecutors around the country on civil and criminal healthcare fraud statutes, schemes, investigative tools, privacy concerns, and compliance issues. He was instrumental in writing and implementing Department of Justice guidance on judicious use of the False Claims Act. Since entering private practice, Robert has continued to build on his healthcare background and expertise. He has represented home health, hospice, and other healthcare providers, durable equipment suppliers, and third-party billing companies around the country in connection with government investigations, overpayment audits by Medicare contractors, and special investigative units working for private payer plans. Robert currently serves as outside general counsel for the American Medical Billing Association and is recommended by numerous healthcare-related associations to their members. Paul Weidenfeld's principal area of focus since the passage of HIPAA has been civil and criminal healthcare fraud investigations and qui tam litigation brought pursuant to federal and state False Claims Act statutes. He has served as the National Healthcare Fraud Coordinator for the Department of Justice's Executive Office and as Assistant U.S. Attorney in New Orleans, handling both criminal and civil healthcare fraud matters. Since leaving the DOJ, Paul has represented a number of providers and individuals in healthcare fraud matters arising out of or related to civil False Claims Act investigations. Paul also has extensive litigation experience, including approximately 50 trials and about 25 appellate arguments before, among others, the United States Supreme Court, the Federal Fifth Circuit Court of Appeals, and the Louisiana Supreme Court. Paul recently opened his own practice to concentrate on building his mediation and consulting practice. Paul, Robert, go ahead.
Well, good afternoon, Robert. And
hello, Paul.
And thank you, folks at First Healthcare. We got an interesting one here today, I think.
Yep, we're going to talk about background checks and exclusion screening and how those issues kind of fit within the overall compliance program that an organization is required to put into place.
But first, I think we ought to apologize by subjecting everybody to those long introductions. You know, we have to we have to do something about that.
Yeah, I agree.
That's too much. I'm tired of listening to all that stuff about you, man.
Me too.
Anyway,
all right, so what's the difference between risk management basics and compliance plan basics?
Okay, so we're going to start with that, right? And we're going to start, the idea is that a risk management plan is sort of the overall, the big picture structure, right? What do they call it? The strategic business discipline. I love this stuff. Supporting the achievement of the organization's objective and the interrelated portfolio. In other words, they're saying, let's not look at silos. Let's look at the whole big picture, right? That's kind of what an enterprise risk management is all about. And what is the definition? Basically that it looks at the whole thing itself. Okay. So that's risk management. Now,
and I can tell you, when I first started out in healthcare in '84, working in hospitals, risk management was all there was. There wasn't such thing as a compliance officer.
it's had an interesting evolution. You're right, because it started that way, and then as risk management evolved, as compliance came just into the insurance side, responding to accidents and so forth. So now it's coming full circle and coming back to healthcare.
It really is. There's no question. It's gone through an evolution.
So let's compare. So risk management is the big picture, and now and compliance. You started in compliance. You were in a hospital. You were in hospital administration, right? You have a master's in hospital administration, don't you?
Right. But we didn't have a compliance plan. I can tell you that. I mean, risk management in those days, we focused really primarily on patient care and medical malpractice and OSHA. And when it came to regulatory matter, those kind of issues really kind of fell all within risk management. They didn't really kind of talk about it in terms of regulatory compliance.
An overall plan.
Right.
So it was like in the late 90s, wasn't it, where the OIG started pumping out all of these compliance guidance?
98, that's right.
And so so it became a compliance plan. So what's a compliance plan versus a risk management program? Is it really?
Well, ultimately, I think they have a lot of the same key components. I think it's probably just the way that you really kind of look at it.
So the compliance plan would be fair to say is that's the program specifically related to the health side of it. Whereas because there are concerns, so for a large provider, that go beyond. They go like into debt services and all that kind of stuff, and that's not within.
That's right.
That wouldn't be part of the compliance plan.
And part of the difference also was because with the evolution of the U.S. sentencing guidelines, of course, where they started giving credit to organizations that had these roadmaps to keep you within the four corners of the law. I mean, that really kind of elevated the importance of having one of these plans in place, because it really encouraged organizations, not just healthcare organizations, but all organizations that are really kind of constrained by these regulatory processes, to really kind of have something out there that would encourage them, if they found a mistake, to correct it, and in some cases report it when necessary.
All right. So they have they share the same goals and a lot of the same processes, although they are different. Some people would say they're completely different. Others would say that compliance is a part of risk management. I personally think that really compliance is a part of and fits in to risk management, but that's a different discussion.
Well, that's this whole new theory coming out with enterprise risk management, which is something that you're really kind of involved in these days.
Exactly.
And it's kind of what comes first, the chicken or the egg.
Right.
I can tell you that many hospitals still have risk management as a subsection of compliance, not the other way around.
And there are turf wars that exist because, wait, the risk managers, you guys are just involved with insurance, and now you're kind of poking in on my territory. Isn't that right? But in an ideal world, and well, maybe this isn't an ideal world, but maybe we'll get there. But in an ideal world, they kind of have they have the same goals, right?
They do.
Quality care.
They do.
Safe work environment. Let's protect the financial resources of the facility, of the organization, and ensure regulatory legal compliance. And these are the processes we identify. And I think this is kind of the same. Is this pretty much is this a redundant slide? There's more words on it, though.
Yeah, you did a nice job putting a lot of words on this page. I'm surprised you all fit.
Yeah, I worked hard at that.
But where does human where does human capital fit in this big picture?
All right, so this is where we're getting into, like, we are talking about the role of exclusion screening and background checks. And so the idea of human capital is, and it's got a new word, I'm not sure, maybe in the last 5 or 10 years or whatever they started calling it this, but it's the idea that the value of your people, right, is your employees. It's the totality of their behaviors. It's how they affect your business, your healthcare, your provider. So the second bullet point is that they are, in fact, your greatest cost. And so it's always amazing to me that human resources may get tasked with finding someone who's in a critical role. They got like a day, right? Instead of understanding that this is like a critical role, these are your greatest cost and
your greatest liabilities.
Your greatest liability.
And frankly, this really does dovetail nicely with the whole concept of the Yates memo, which stands for the idea, of course, that, you know, ultimately, I hate to compare it, but it's kind of like guns don't kill people, people kill people. Same thing with corporations. Corporations don't violate the law. People working in corporations violate the law.
That's a really good point. You know, and that's something we don't necessarily think about. We insulate the world of, well, it's a mistake and we can fix it within the context of, you know, within the healthcare. But in fact, the Yates memo, it says, goes for individual liability.
Oh, individual culpability. Then they say, you know what? I know we've done things differently in the past. I know in the past we've gone after big pharma, we've gone after these big banks, we've let the big banks pay lots of money. Everybody gets away. Not in the future. Corporations are fictitious persons. There are individuals behind every crime.
You know, and I think it's these big settlements that really has spurred the Yates memo and the focus on individual.
Absolutely. It's outrageous. These huge bank fraud cases and nobody goes to jail.
Well, except that not only do they not go to jail, but
we bail them out.
We bail them out, and the individuals start getting paid to fix it, large sums of money. Now, then, you know, I'm not passing judgment on all that, but the fact is that where is the individual culpability in those situations? There is
no deterrence whatsoever.
And the same as in the healthcare case. In these huge pharma cases, they may settle a case or hospital cases for $500 million, and nobody gets, you know.
And all pharma does is raise the price of a pill by 0.5 cent, and they've made up the money over a month.
All right, so we've gone off on that soapbox. We'll get back off it.
All right. But let's talk about it, though. So now that we've kind of gotten to the point of when it comes, at the end of the day, whether or not you're going to succeed or fail, in large part depends on your people.
And that's really, right, that's what this webinar is about. You and I are really focused on this. You know, you could talk about we need to have systems in place and we need to do this and that. But at the end of the day,
you have a non-compliant employee, none of it matters.
Right. If you've got someone who's a really bad employee, you know, a Dr. Doom kind of guy or gal, who they exist, you want to keep them out. Look at this. Here's our list. And if you think about it, virtually everything that can go wrong and all the things you're protecting against really come down to like a person or person's conduct, right?
It really does.
Okay, safety, professional liability, your liability risk, drug diversion. You know, what is a bad employee, you know, going to do?
And the really sad thing here, Paul, is we pour tons and tons of funds into auditing and monitoring, training, and the rest of it. But what we don't do is spend enough focus on the front end before we let bad guys walk into our facility and work.
That's really true. If you think about, you and I have represented a lot of providers, and we have seen a lot of HR departments, and I have yet to see someone, you know, who's heads HR or someone in HR that says, you know, it's amazing. I'm like really staffed well. And I can really make sure that we do all of the things we're supposed to do. I've yet to meet that HR person.
No, it's shocking how poorly screening takes place in most healthcare organizations, and what little work goes into checking references and conducting a bona fide background investigation.
Now, don't get us wrong. We get it. Okay, we've been in healthcare. Robert's been in healthcare for 30 years. I've been in healthcare for over 20 years. So we understand the pressures when someone says, we need someone to fill this spot. I mean, we get it.
We're looking for a breathing body that's licensed.
So we understand the tension there. But if you look at it, we've just talked about all of your liability, right? Comes down, or most of it comes down to individual action. And, well, not surprisingly, your costs involved are there. It's not in your physical plant. It's not in your heating, and it's not in your your debt service for the building that you bought. It's folk, right?
Yep. So almost 60% of your costs are really represented by your people and their their wages and their benefits.
Exactly.
And really, you need to take that into account, because you need to put a lot more focus on those issues before you bring somebody in. The hiring process is something that we need to put a lot more attention to, because at the end of the day, as we're going to discuss, there are a lot of things that can go wrong in the hiring process.
So we can go through. There's one thing I want to say about this slide, and that's a company can use their hiring process as a competitive advantage. And they can look at it, and some companies see it as that way. And the more good people you attract, the more other good people want to be there, and the better the environment. So it can be a competitive advantage. It's not, we have to stop looking at it in terms of just another requirement, but as something that benefits the company as a whole.
That's an excellent point. It's also important to kind of keep in mind that it only takes one bad apple to really ruin a workplace.
Haven't we all seen that? The one guy or gal that's going around that
bad talking, causing problems.
Right. Either really bad stuff, or just individually, just sort of being the person that everybody kind of walks away from.
Doesn't do their job. Their task ends up being passed on to somebody else.
All right.
Okay, so pre-employment screening. All right, so we've talked a lot about the importance of it. We've talked about the fact that everyone's really probably not doing what they need to be doing on the employment side before they put them in the front door. But what can you do, Paul?
Well, so what is a background check, right? So this is a slide that's probably more obvious than, or pretty obvious, but let's just kind of say it's like, we want to find out, are they who they say they are? And we're going to see in a little bit that that's not exactly an automatic answer. Have they provided accurate information? Are they qualified? Are they legally able to do it? Is it someone that you want to hire? Now, you can go through it all Robert, you can do the reference checks, public information, criminal background checks, licensing, and work history. So there's
no, wait a minute, Paul. Stop right there.
Stop the process.
Who they say they are. So are you telling me that if we check the references and we check their licensing and their verification of work history, that's not enough? That perhaps that's something that can be problematic?
Well, we're going to see in a few slides that, in fact, they might not be who they say they are, or they might not have, well, we're going to talk about that in a few minutes. Let's talk about the types of background checks that you can do. Most that I know of kind of do the top one, that basic one, right? They check a few references and
what does that mean, checking a few references? They call references that the applicant gives them.
Correct.
So there's two problems wrong with that. First of all, an applicant, although I've actually had applicants give me names of people that have said horrible things about them, but most applicants are always going to make sure that they're going to give you names of folks that are only going to say wonderful things.
And the other thing is that even if they give you stuff, we won't, who's going to say bad things in a reference check? When somebody calls you, you're really reluctant to say bad things about somebody, even though you haven't liked them. And we've all been in this situation, let's be honest, where you haven't liked the person. You're so glad when they're out the door. Yay, happy dance. Then someone calls, but you don't want to say that, right?
That's exactly right. And I used to work for an individual and understand, I don't care if you were the greatest employee or the worst employee, his policy was when you left, the only thing he would say is, he was here, now he's gone.
And that's kind of our policy here.
Pretty much is. We verify dates of employment, and that's about it.
So what else so just calling, and it just doesn't really do it. You can also, there are some criminal background checks. Most people will do the required ones, depending upon, if you're, what you provide.
In many states, like Texas, you can go in and you can check those yourself.
Right.
I mean, it's not restricted to just law enforcement agencies that can check that.
So all we can say is that when you're doing it yourself, you really need to be, you got to kind of go the next step and call, perhaps if they identify places that they've worked, not just call their references there, but try and get some other people. I know it's a burden. We know it's a hassle, but think about it. It makes a lot of sense, and particularly in light of what we're going to say. Now, some people do third-party background checks. Those are expensive. That means you're hiring someone to do it, but they have to comply with the Fair Credit Reporting Act, which means they've got to, if there's an adverse action, you've got to tell them upon what you're basing it. They have an opportunity to respond. It's a quagmire.
And we've also seen, as I'm sure you can describe for us later on, that these third-party background checks aren't all they're cracked up to be.
No, they're not. We've got some interesting information on that as well.
All right, so what about doing a criminal background check? What's the problem with that?
Well, you know, we'd like to think that there's a single database. Now, some people would like to say that, you know, our privacy concerns are we don't want to have like this one single database where everybody knows everything about everyone. And that, you know, I'm among the privacy protectors, frankly. But there is no single database. There are, you know, you have access for certain, if you're in a certain provider type, you're allowed access to certain information. There are sex offender lists, or like Texas has a kind of like a bad employee list. You know, there are, you ought to, I think, do the basic criminal background checks if you possibly can, frankly.
And you have to be careful because now, of course, EEOC is pushing very hard this idea that you can't even ask, unless it's required by a position, and you can justify it, you can't even ask certain folks whether or not they've been convicted of a felony.
Right, and even if they have been convicted of a felony, you can't automatically
exclude them,
disqualify someone on that basis, because unless it has some relationship to their position. Now, it's hard to imagine. I mean, there are some felonies which are fairly minor, which perhaps don't relate to anything, and you know, we all know of people that it's a bad deal. But
smoking a little dope, something like that, perhaps.
You know, when they were a kid, and it's a felony, they haven't gotten rid of it, something like that. But most people can usually find it, but you have to be careful. You can't, in fact, you know, there are check-the-box states.
That's right.
Where you can't ask it until like the second round of interviews. So be aware.
Okay. Plus, this is very important. You know, there is no litmus test when it comes to checking an individual's background. Every state is different.
So the home health, so like there are no federal laws for home health and hospice, for example, and the same thing for nursing home. They say the feds punt and say, well, you have to, you know, follow the state. But now if you're in more than one state, you know, some states require background checks before work, some after you can start, and it can be in progress. Some don't even, some say, well, you can't hire people with felonies, but don't identify or enumerate which felonies.
Mm-hmm.
We're not, sounds like we're like just making more trouble, you know.
But the fact is, you've got to understand what the rules are in your state for the particular position that you're going to be filling.
I think that that's really the bottom line. Is make sure in your state, if you're providing whatever service you're providing, it may be, and if you're in more than one state, then you got to follow it in each state.
Now, this is one of the most interesting facts I think that we're going to cover today, Paul. You know, you think that in today's world, with the internet like it is, that folks would really avoid giving out false information because they would figure that you could figure it out pretty easily. But I think, in fact, just the opposite is true.
And you know, that's a real book, by the way, the fake resume book. I believe that's a real book. The estimate, and you know, who really knows, but the estimate is about half of all applications contain false information. Now, sometimes that false information may be, you know, insignificant, like they say they finished college, but they only have 3.5 years or something along those lines. But sometimes it's a lot more significant, like they make stuff.
They could say they have 3.5 years experience working as a home health nurse for an agency that is now closed down.
Sham certifications.
It takes about 2 seconds to look up a home health agency that's been busted, and then all they have to do is list that on their resume.
A friend of mine called me the other day and said, hey, guess what? And this is a true agnostic. He says, I'm a minister. Someone wanted to get married, so I had to find a place where I could be a minister so that I could marry them. They wanted me to do the service. It was, there he was. He's now a minister. Look at the next slide.
Oh, gosh. This one, I love this one, Paul.
All right, now,
I love this.
That's not exactly the name because, you know, we are lawyers and we wanted to be sensitive about putting the real name, but it's sort of similar. But everything on this slide comes from that website, that careersomethingorother.com.
Yeah, if you want to know where it is, you can actually call Paul and he'll tell you where it is. But the fact is, there are a handful of these websites out there that we're aware of that for a relatively small amount of money, they will completely recreate your life. Everything from a new degree, to a resume, to references, recommendation letters.
You provide. Just give us the area code of that, of where you're applying. Give us their area code so we're local.
And the story.
And, right, we're in the industry, and how many references they want, and what dates of employment do we need to cover? Do we need to start from jump, or are you okay for a while, and what you're applying for?
Now this is so important because you have to understand these third-party background companies that you're paying good money for to conduct these backgrounds for you. They have no way of knowing if the person they're talking to is real or not.
That's pretty.
It's virtually impossible to know because they get as you indicated, they get an area code in the city where the job was supposedly located, and it rings right to them, and they have all the information right there, including the duties that you did, the dates of service, what your performance was, the whole 9 yards.
I would hope that a true third-party vendor, they have access to other information about that would be inconsistent with what they're making up, just the next level. So if they just did it on a superficial basis, as we're going to see some do, then they're not going to find it. But if they do a good job,
Paul,
they're going to find it.
As we're going to see, investigators, third-party background companies working for the federal government, investigating individuals that would have classified positions, made stuff up. So why would we think that other third-party background companies would not do the same thing?
Well, they might. I'm not willing to.
I'm not saying that they are. I'm just saying I'm very, very concerned about the accuracy of the information that we're getting.
So my thought would be if a good background check company would be able to pierce this stuff. But this is another one. When your employer contacts your previous employer and professional references to hear all the wonderful things you'll do, our service is very authentic. Unless you tell someone, they'll never know. I don't think that that's true. I think that that you can pierce it, but they do make it harder. By the way, these companies all say they will not provide their service if you apply for a federal government position. So, because I'm assuming that means that they think that they are above the law or can skirt around the law when it's private, but that if it has something to do with the feds and they're assisting someone to get into the feds, that could be problematic. So I know nobody here would be thinking about using such a service, but they do have that caveat, and that's about the only caveat they have. And this is what you were talking about before.
Yeah, this is what I was talking about, Paul. I mean, this is an example of one of the most egregious cases I've seen involving these background checks.
It's
a case that you found when you researched this issue.
It wasn't easy to find this. They weren't. I don't think the government was very proud of this, but the government had a quitam or a whistleblower case that said that the company doing the background checks, they're not doing them. They're pitching them, and so they started looking at them, and they ultimately, there was a $30 million settlement to resolve allegations that this company was simply wasn't doing their job and wasn't really doing the background checks. Now, of course, you know how they got paid? They got paid as a set-off to money that they owed that company. So basically, there was like no penalty, no anything in. Who knows how many people were hired?
The one stat that I love is this one where one of the reviewers supposedly completed more than 15,000 background investigations in 1 month.
Well, he was a reviewer, so he was able to review, what's that, about 500 a day? He was efficient, Robert. Come on.
Unbelievable.
Yeah, so, and you can see that, so what does it tell us about background checks?
Well, I think what it tells us is you cannot rely on just a background check. You're going to have to conduct more due diligence on your own. It's so important, as we discussed since the first slide, the folks that you let in your front door are the ones that can really, that's where you're spending your most money. That's where you subject your organization to its highest potential liability. And you have to take steps to make sure that you get the best people in the best positions.
So, but it's not all gloom and doom, right? I mean, I know we're kind of, as I'm listening to each of us speak, we're kind of pessimistic about the ability to screen your employees, but in the real world, particularly in smaller providers, right, you have the ability to know people. You have the ability, you know who's in your area, and you have the ability to do, you know, to not just to take the next step or the next two steps. I think that's what's important.
In a weird way, it is easier in a small town.
It is.
Because everybody knows everybody.
It's a fact. Now, you know, so my advice on that is that I think you can do third-party companies. I think that there are ones that do a good job, and I think that they can find, you know, the significant lies, maybe not the little one, the little white lies or the little exaggerations, but they can find them. And I think that with good interviewing, you know, if somebody says that they did such and such a job, right? You know, there's a lot of things that, particularly in healthcare, every job, and HR knows this, every job has things that are particular or peculiar to that job. And I think with some good interviewing, when you ask somebody, if they say they were a tech, a radiology tech, you probably know something about radiology if you're in HR, and you know how to ask them about certain machines. Did you work on this machine? Did you work on that machine? Did you, how did you like positioning? And if you don't know anything about that, you ask someone beforehand when they're coming into the interview. You know, what kind of things would an experienced tech really know, and what kind of questions could I ask them? What do you think about that?
I agree. And with regard to education, checking education, there really isn't any substitute for you looking up the number yourself, calling the institution, talking to the registrar's office, and seeing if they have a degree. It's not sufficient to have an individual come in, even with a copy of their diploma. You can literally buy a copy of any diploma. You can get a Harvard diploma today on the web with your name on it.
You know, and you get a release for the information. And by the way, one last thing on this, and this I think is important, maybe? Yeah, I think this is important, and that is the fact that, you know, you can hire someone provisionally. I mean, I think that what happens a lot is that we decide and then we figure, oh, well, there it is. But there's no reason why you can't send off for verification information. It sounds good. You think it's right. You hire them, but you say it's provisional. And, you know, because you have a probationary period or whatever. And during that time, you can continue to look a little deeper into their background. There's nothing wrong with that.
That's true, but there are some things that you should not do even on a provisional basis.
Agreed, absolutely. I agree with that. Absolutely.
Such as screening.
All right, so that takes us to, here's one. What is an exclusion and what is exclusion screening? Well, let's talk about an exclusion. It is what? An administrative action taken by the Secretary of Health and Human Resources, which is delegated to the Office of Inspector General, that bars a person from having any participation in any or all federal and state health care benefit programs.
It's essentially the administrative nuclear bomb.
So
they can't work or accept Medicare, and they can't work for anyone who takes Medicare or other federal health benefit programs.
And here's the important thing about that. The second bullet. You know, the reason people are excluded, this is not just, you know, oh, I was excluded and I blah, blah, blah. What if they were excluded? The reason ceases to exist. If you're arrested or convicted, right, the reason might make a difference. You might want to hire someone who's been arrested or convicted for any kind of crime, depending upon the explanation, and it might be okay. For an exclusion, there is no explanation. It doesn't matter. They may have a good reason. It may be a very sad story, but the fact of the matter is they are excluded because they are deemed to have to be an unacceptable risk to patients and to the federal fisc. So,
and the point with that, Paul, also is exclusion actions are not meant to be punitive actions against individuals.
That's right.
Frankly, the government could care less about penalizing these individuals. They've already been penalized when they were convicted or whatever other action was taken against them.
Good point.
The sole purpose of the exclusion action is to protect the program and its patients, period.
That's exactly right. That's a really important, we don't focus on that enough. That's a really important point. So in other words, it's done with them. They've been punished however they've been punished. Doesn't matter. Now, this is all about putting people on notice that these are people you cannot hire. So,
and this is something you can't do on a provisional basis.
Correct. Absolutely not. So as you say, why do people get excluded? Well, about half and half are mandatory and permissive. The mandatory ones, mainly drugs, right?
Yeah.
Felony. They have to be a felony conviction for it to be mandatory. It's a drug, healthcare fraud, or patient abuse. One of those three things. And in fact, those are the main reasons for the permissive ones too. It's just that they may not have been convicted of a felony, or it may have been not a mandatory felony.
We also see a lot of board action cases on the permissive side.
Right.
Now, just to be real clear, just because it says permissive, don't take that to mean that there's a good chance that the government is going to waive its permissive authority.
That's right.
In most cases, if you're eligible for permissive exclusion, OIG is going to exercise that authority.
So, and if you're excluded a permissive one, it doesn't mean it's not any different than a mandatory one, except that there's a max of 5 years on the permissive one, and it's easier to get back in the program, but not automatic, right?
That's right.
So if you see someone that they say, oh, I was excluded 10 years ago, so, and it was a 3-year exclusion, so you can hire me, the answer to that is?
Not yet. Not until you get a letter from OIG saying that you are eligible for readmission.
So that person has to go back, and you still have to check them. So.
And we've had several of those cases, Paul, where an employer comes to us and they say, look, we thought it was okay because they brought in the letter. The letter said they were only excluded for 5 years, and that expired 5 years ago, so we didn't think it was a problem. Well, I'm sorry. Unfortunately, it is a problem.
And frankly, in exclusion screening, which we are part of, frankly, in exclusion screening, the largest percentage of cases that we have found of excluded people working for providers are folk who were excluded a long time ago, and when we came up with the name and showed it to them, they go, oh my gosh, she's been with us for 5 years. This was back however long. She said it was no longer part of anything. It was over. It's not over until they have a letter that says it's over, and it happens quite frequently. Well, at least frequently. So.
Now, what's the impact of an exclusion action, Paul?
Oh wait, you lost the slide with my.
Oh, I did.
Yeah, that's my.
There we go.
That's the height of my my ability to do stuff with this with these programs. Radioactivity, right? As you say, the nuclear bomb. Can you do anything? What happens? Nothing, right?
Right.
So can you, well, what about, let's say they say, oh, well, they're in the front office. All they're doing is the billing. All they're doing are administrative tasks. Can they do that?
No. If 1 penny of their salary or overhead comes from federal or state health benefit monies, you've got a problem. So theoretically, I suppose if you've got John who is being paid cash to mow outside, that probably wouldn't be an issue. And you're not going to have to worry about companies that like utility companies or things like that, things that are mere conduits like electricity or the phones or the rest of it. But this idea that just because someone doesn't have any direct patient care that you don't have to worry about screening, that's completely incorrect.
And it's employees, vendors, and contractors. So it's any employee that is related to any federal health care program. And our thinking, frankly, is if you provide a service for which you're reimbursed, it's just going to be just about any full-time employee. It's not worth your effort to try and figure out the handful of people that aren't. You just bump them in. The vendors and contractors, it's, as you say, there are some that don't, but like the linen, linen is related, that's to patient care. If you're in a nursing home and they're providing the linens, I think that you absolutely would have to do that.
Well, I think you've got to do it for your hazardous waste. I mean, all those are supplies they're all part of that. All fits into the overall cost scheme that is used by Medicare and Medicaid to come up with reimbursement.
So, someone that collects the trash outside, probably not. Someone that comes inside and gets the boxes, probably so. What happens? Well, so these are some of the consequences, right? Civil money penalties, we get asked, well, why, how often do they do it? The question is, they do it as often as they find it. So whenever they find one, then they start going back. And they can impose a civil money penalty for, literally for upon every claim that you make. Now they will often go that far, but if you fail to screen on a regular basis, on a monthly basis, the OIG takes a position that is a violation of the civil money penalty liability, for which you may be liable for up to $10,000 for each claim that is submitted, and each exclusion, 3 times the amount.
And I think it's interesting, if you look at the OIG website where there's a huge list of all the practices and organizations that have had to pay CMPs. On every one they say, this organization knew or should have known. Now the reason they say should have known, Paul, is because
there is a knowledge element to it, but they convert it to a should have known element.
And that's part of the reason is because the exclusion law has been out there for, what, 30 years, 40 years?
Yep, absolutely, since the 80s. And what they basically are saying is, look, you need to screen, you need to screen. And so if you had screened, you would have found this person was excluded. Since he was excluded, I'm going to assume you didn't screen, and you knowingly didn't screen, because you're assumed to know the law.
That's right. That's right. And in fact, many states now, when you actually sign up to be a participating provider, or you have to re-up, you actually have to swear that, in fact, you're conducting these screening activities on a monthly basis. So
the next slide tells us there are.
Before we go to the next slide, though, Paul, I do think this is a fascinating one to me. How a pharmacy chain had a pharmacist that was excluded. Now, this is someone. Understand the services were medically necessary, and they write a prescription. They send the prescription to they give it to the patient. The patient takes it to the pharmacy. The pharmacy fills it, but it ends up being filled by a pharmacist who's not.
Well, and the chain, I'm not sure where it is, but yes, the chain had a whole bunch of pharmacists who they didn't bother to screen. And so 21 million, that's by far the largest settlement, but they have been very much focused on pharmacies. They focus on, it's kind of like when you do a certificate of need or something like that, you're presumed to know, right? So they do the same kind of thing.
Okay.
What are the requirements? We have to pick it up. What time is it? Anyway, requirements. So there are people who say, well, there's no single document that says the OIG requires monthly screening. And that's true. They don't specifically say that you have to screen every month. But what they do say is, if you don't screen every month, we can impose civil money penalties for your failure to do so.
So what they're essentially saying is, we're going to give you a pass on CMPs if you're screening every month and you catch it. So let's say that you hire somebody on day 1,
right,
and on the day one of the next month, you're doing your screening, and you find them. So now you've had them there for, let's say, 30 days.
Well, except that you need to screen them on hiring too. So
well, on day 2, they hit the list. Let's say that on day 2, they hit the list.
Well, right.
So for 29 days, they were on the list, and you shouldn't have known. They're not going to let you walk away without paying an overpayment. Probably. You're still going to have to pay that, but they're not going to hit you for CMPs.
Right. And this is so that the kind of thing that it doesn't, someone may not be on the list, and we've had this several times, that they may not be excluded when you hire them.
It's happened a number of, it has happened several times that we know of. Yeah.
And then you screen them and you hire them, they're fine, and 3 months later they hit the list for something they did in another state. Mm-hmm. So you're going to get, since you've been screening every month, they're not going to whack you for those 3 months, the civil money penalties. However, you would be responsible for the overpayments for those months. But typically, if you've been screening, they're relatively lenient for those months. If you haven't been screening, then they are not.
That's right. And now this is important, Paul, because in years past, and I mean, I'd have to go back at least 8 years, but in years past, it was pretty common for us to recommend that people screen at least on an annual basis.
Well, that was their guidance up until 2013. In 1998, the guidance was annual screening. In 2013, they changed the rules and they said every month. And so since then, for the last 5 years, that's been the regulation, and they have been enforcing it more and more. And in
today's society, where we have such a mobile group of folks, especially nurses that are licensed in multiple states, they may move from one state to another, and it may be months before an action is taken against their license in a former state.
Absolutely. And so states also, let's not forget that states. So the OIG has its monthly requirement, and if you do it any less than a month, you're just making a mistake. It's just, but the states also have the requirement in the context of their Medicaid programs. So CMS had mandated back in 2009, and then they affirmed it again in 2011, that states require any provider that gets Medicaid dollars to screen on a monthly basis. At this point, almost every state has adopted that standard. There's 1 or 2 out that do it quarterly, but basically every state has adopted that. But in addition to the monthly requirement, as in Texas, as a part of becoming a provider, Medicaid provider,
and in Louisiana,
right, and in several other states,
New York,
you must certify on your application that neither you nor any of your employees, vendors, or contractors have ever been or are currently excluded from any state or federal health care benefit program. So that would mean the Medicaid exclusion list, of which there are 37 states, have their own exclusion list. You are certifying that they are not on any of those exclusion lists, as well as your state's exclusion.
Now, hang on, Paul. So you're saying that it's not enough to just look at the OIG list?
Absolutely not.
You have to look at all the state Medicaid lists too.
You are always required to look at, if your state has its own list, you are at a minimum, you are required to look at your state list on a monthly basis as well as the OIGs. If you read your provider agreement with Medicaid, most states now have some sort of obligation, not all, but you need to read yours, that say in many states you are required to certify that none of your employees or vendors or contractors have been excluded from any state, and in fact, in some states it's a criminal violation or an administrative violation if you fail to do that.
In Louisiana, it's actually a criminal violation, isn't it?
And it's an administrative statute in Texas, and so screen easily. And frankly, screening a lot is not difficult from vendors can do it with relatively inexpensive.
Well, and that's what's so confusing about it, I think, is if you're going to do one, you might as well do them all anyway. Because think about this, guys. Once again, this is not a check-the-box situation. You don't want these people in your organization. That's the whole purpose of this, to protect your patients, to protect the program.
And to protect your organization. And so that's the loop back, right? That's where we started. All the people themselves are your biggest cost, your biggest risk, and so we're looping back to that.
All right, so we talked about how important it is to keep all the state lists in the picture. But are all the states together in one place?
Oh no, not only are they not all together, they're in different formats. There's some in PDF. One state, I believe it's New Jersey, actually has their list in a non-searchable database. Now, figure this. These lists, by the way, these are public notice of people who you cannot hire because they've been excluded. Yet, they're not in any uniform database. They're not in any uniform format. So what do? You really do need to have a third-party vendor. Third-party vendors are very reasonable. It's a lot easier than doing it yourself, but you just need to be doing that. So,
now this is one of the craziest decisions I've heard yet. This one, the pharmacy was penalized because it filled a script that was ordered by a doctor who had been excluded.
Well, obviously several. So I think what happened was, so you've got this doctor who's writing these prescriptions, and the doctor probably had no money at the end of the day, squandered it for whatever reason. So they went after, the pharmacy and said, you needed to check the pharmacist who was writing those prescriptions, which is,
Well, now to be clear though, there's nothing against the law, even if he was excluded. There's nothing against the law for him to see patients and treat patients and prescribe for patients.
Assuming he has a license.
But he can't, those prescriptions he's issued can't be paid for by Medicare or Medicaid.
They can be perfectly valid prescriptions.
A patient can take them in and pay for them with cash.
Absolutely, as long as they have their license.
Yep.
Because just because you're excluded does not necessarily mean you've lost your license.
Exactly.
It's an interesting thing. So we're almost out of time, so we're going to zip through this. Convictions, they are reliable evidence, but the employee, they say that if there's a disparate impact, you can't just automatically exclude. We talked about that before. Arrest. Exclusions you can. Why? Because they're a final action. You can, they're public notice.
That's why, background checks are fine, but you really need to also make sure that you always conduct your exclusion screening.
So then, if we look at it, so here's our question: if there's an accident, an incident, or whatever causing harm, and the harm was related to someone who had been excluded or convicted of a serious crime, is a judge or a jury going to be sympathetic to your explanation that, well, I didn't screen because, what? It was too expensive, I didn't have time, we were in a hurry. I don't think so.
No, not at all.
I think that this is what they're going to look like. Right. This is what it's going to look like to a jury. The monkey that's not seeing or listening, the guy with his head in the ground.
Right.
So this is why, you need to check on. There's there's not strong information sharing, and we're at 5 bucks. So let's see if we have any questions. But this is just a story of someone why you have to check all the states. You can see that person was not excluded for a very long time, only excluded on a limited database. So you've got to be thorough in it. So takeaway points.
You really do need to.
Do we have any questions before we take away?
Any questions?
This is Catherine. We do have some questions.
Sure.
Okay, so our first question is this. What if we outsource our billing to another company? Do we need to worry about their employees being on the exclusion list?
Yes.
Technically, we are paying them out of reimbursements from government payers.
Yes, billers and their employees, they're a contractor, and contractors are required to do their own screening. Now, you can either ask them for a list and do the screening for them, or you can get some type of certification from them that they are doing the screening themselves. Ultimately, you're still accountable, so I would want some type of proof or assurances that they are doing the screening. But absolutely, billers have to be screened as well.
So the OIG, that's a good question because that comes up a lot. I think our position would be you should screen the company. right? And you should screen whoever whoever owns the company itself, and you can require them to do the screening. It should be part of your contract, part of your billing contract that says that they do the screening. But it's not enough for them to just say, okay, we'll do it. You really need, the OIG says, you really need to require something from them that shows they are doing the screening.
Like an invoice.
Like an invoice, or like that if they're doing it individually, like screenshots or something. So you can't just say, all right, you can't just pass it on to them and then not worry about it. You can pass it on to them. You're still responsible, but if if they show you that they're doing it and they demonstrate it, then you should be okay. So that's the answer, I think.
Okay. Let me see. Here's another one. Do we have to screen pharmacies as a physician writing scripts? So this is kind of the opposite of one that you had.
So do you have to screen the Wait.
Yeah. Yeah. So you're a doctor, and you're going to be sending a patient to a specific pharmacy?
Yes. So you do. No.
Okay.
Do we have to screen pharmacies as a physician? So you're a doctor, and do you have to screen the pharmacies as a physician writing the scripts?
Well, first of all, there's two scenarios. One would be, in most scenarios, you would give a script to the patient, and they would go to their own pharmacy. So I think they have a hard time pinning that on you. On the other hand, though, if you're using a compounding pharmacy, that's a situation where you pretty much direct the patient where to go. And yes, I think that you ought to be screening that company, and I think that you ought to be having, just as with the billers, I think you ought to be telling the compounding pharmacy, I expect you to screen all your employees, and I want certification of that.
Right. I think Robert's got it exactly right. Depends upon the relationship. If you're just giving a prescription to a patient, they're going to go wherever they go, and I don't think that you have anything to do with that. But if you're directing them to a specific place and they have a relationship, then yes, you probably ought to. Now,
that's a contractor at that point.
Well, I don't know if he's your contract. Yeah,
I don't know. But I'll tell you what, those compounding pharmacy relationships are very special, and docs will send them to one or two specific ones depending on the prescription. So better safe than sorry.
Probably so.
Okay. Okay. Let's see. I have another question here. Please clarify the exclusions screening for a new hire that was screened upon hire and was good, then the exclusion appears after 30 days.
So you've screened them on hire and they were not excluded. And you find out within 30 days, or in the next cycle of screening, in your normal cycle, you find that they've been excluded in that period of time. And you've checked back and you made sure you didn't make a mistake the first time and they weren't on the list, but you missed it. So if that's the case, what you would do at that point is, you now have depending upon their responsibility, you have an overpayment. It may be a very minor one. If they have an administrative task, they typically will calculate that overpayment in the context of their salary.
There's a bizarre formula that they use, so it's going to end up being something probably negligible, frankly.
However, if it's a biller, a direct biller,
or a doctor,
right? Anybody that has a billing number, or then that's different. But the OIG has said that they're not going to look at you in the context of a civil money penalty in that context, because you are doing it, you've screened them on hire, you're screening them.
And frankly, what's going to happen is they're going to send you back basically what I call a no-pros letter, but a no prosecution. Essentially, it's going to say, we've decided we're not going to take any action against you for civil monetary penalties. We're going to direct you to deal directly with the MAC to determine the amount of any overpayment that may be owed. That's what's happened in the cases that I've handled.
Right, and as long as they're not someone with a billing number itself and directly writing, it's going to be negligible. You're going to be fine.
Okay. All right. Well, I think we have a few more questions, but I think we're about out of time. So I don't know if you can put up your last slide with your contact information there. Okay.
And listen, for a lot of really good information, go to exclusionscreening.com. or give Paul a call. He is the guru in the country on exclusion issues. There's no one that has researched this issue more. I can honestly say he knows more about it than anyone in or out of the government.
And I will just finish by saying, you know, it really is. This has been my focus for the last couple of years now. That, you know, who you hire and how you make those decisions is just so important. You know, don't get sucked in by the pressures. I understand how difficult it is, you know, when you're under pressure to get somebody on board on the night shift, or you need a nurse, you need a whatever. You know, you need a tech, you need to fill a slot. But, you know, they are, in fact, your greatest cost, and they are, in fact, your greatest risk. And so, you know, it only makes sense to do the best you can and to really really be careful. So,
okay, good.
Thank you.
Thank you very much.
Good.
Thank
All
you
right,
very
and
much.
thank you. And you can register for any future webinars or request a demo of our compliance solution at our website, also at firsthcc.com, or call us also at 888-543-4778. And thank you so much for joining us, and thank you, Robert and Paul, also. Thank you.
Thank you. Bye-bye.
Okay, bye-bye.